Neither the ADA nor Section 504 applied to the study abroad in this case. So, there was a deaf student who had requested an ASL interpreter for a study abroad program in Ireland. ASU denied the request. Unfortunately, the Office of Civil Rights said the denial was acceptable because the laws do not apply in Ireland. But on the flip side of this case is a secondary set of cases where OCR determined the law would apply under extraterritoriality. In 1990, a student with a learning disability filed a complaint with OCR. Apparently, the student had been provided the wrong type of computer, so the OCR made the determination that since the university received federal financial assistance, they were required to adhere to the ADA and Section 504. And then in 1992, again, a deaf student had requested an ASL interpreter for, oddly enough, a study abroad program in Ireland. The program denied the request. This time, OCR disagreed, stating that extraterritoriality did apply. Now, you may be a bit confused, asking, then which is it? Some people agree with OCR's rulings. Some people have tried to resolve this problem by saying, look at the facts. There are some study abroad programs run by American universities, and there are other study abroad programs that are not run by American universities. Now, you may be thinking, if it depends on the judgment from OCR and you disagree, you may think you could appeal to the Department of Education. Unfortunately, the Department of Education has washed their hands of these complaints. Therefore, they do not get involved. If the law states within the United States, then it has to stay contingent within the U.S. until the Supreme Court does something about it. And currently, the Supreme Court does not care to address this issue. So, in the case of overturning the Arabian ruling, in 1991, this was an employment case. In this situation, the court said the ADA discrimination laws were not applicable. From there, Congress said, not so fast. Then they went back to the building and changed the law, overruling the court's decision. Strangely enough, they only made this change to Title I of the ADA, meaning only in the context of employment. Ironically, this allowed disability discrimination, traditionally covered by Titles II and III.